thoughts. I'd like to go back to this whole thing as to how much you have to disclose in the sense of going back to social media and whatnot. Because, and we've seen this happen, a party loses, and then suddenly that party's lawyer starts searching and starts going, okay, let me just do all the research possible on this arbitrator. And lo and behold, I discover that that arbitrator sat as an arbitrator with someone else. Of course, that was disclosed in GAR because it was a well-known case. Uh, Maybe if they would have looked at your CV that you have published on your website, you're not hiding anything. At what point is something, so out there that you really don't have to disclose it? Or do you always have to disclose it?
This is fascinating because in this WADA case that I mentioned, the Swiss tribunal went at length into analyzing whether the fact that the Olympian had looked at social media to search for things after the fact was an element. And what they said was if the party starts going into social media at length to find out something, it probably means that that they have a reason to think that the arbitrator is not independent or impartial already. So they didn't factor in this something as being against the party challenging. It factored in as being part of human nature. You're going you're deep diving into social media after the fact because you may have already considered something was wrong. How much is enough and how much is permissible? I think the IBA guidelines use a term, reasonable inquiries. This is something for the arbitrator first, the potential arbitrator, to make reasonable inquiries to see whether there's something to disclose, but then also to counsel and their parties make reasonable inquiries once you have an appointment. So again, we go to a parameter that is a standard of reasonable inquiries that probably judges will gauge differently depending on the circumstances. But it's whether it is reasonable to spend one whole week with your junior team looking at everything on the website. That may be reasonable if you belong to a big law firm and you have a high stakes dispute. A smaller case and you're a solo practitioner and you're not aware, you don't belong to the arbitration community, maybe a reasonable inquiry will not entail many days of deep diving into the web. So I guess it's proportionate to the whole set of factors, right, involved in that case.
But that's something we deal with on a regular basis. Just like last week in a SEAC arbitration, there was an appointment of a well-respected arbitrator as a sole arbitrator. He came back with a number of cases where the opposing counsel had been either part of a tribunal that they were a part of several years ago, or even opposing counsel in an arbitration where they were acting as an advocate. And as I explained to the client, that's to be expected. I mean, you want someone who is experienced in arbitration and in the space where your dispute is, and you would expect that if your opposition is also active in the arbitration community. We're not that big yet.
But let's go a little bit further. Think if you're in Peru, and in Peru, everything is arbitrated because any dispute with the government goes to arbitration.
Right.
Well, now it's not talking about the past 3 years because the concept of repeat appointments is rampant. That's just a different situation. You can't just go ahead and say, oh, well, this individual has been appointed by this firm 15 times. Well, yes, because
exactly,
there's a limited pool, and that makes a big difference.
Exactly. And then then there's the expertise. What if you have a repeat appointment of this arbitrator that is known to be a specialist on this type of disputes? Is this issue conflict, right, or not? Then we go into the issue conflict, which is something different, but that can occur. And this is what's going on in certain countries. Yes, Peru and in Brazil, you have a big community, but you also have repeat appointments and you have arbitrators with loads of cases because there is so much arbitration that doesn't seem to be always a problem. Sometimes it is.
Well,
Wasn't that part of the issue with the Halliburton case?
Exactly. So in that case, you had one arbitrator that was sitting in different chair in one and wing in another, and I think a third case. And what happened then, it's not even that old, but in that situation with that particular sector, the court, the UK Supreme Court said, after reviewing amicus curiae from different institutions that not all had the same views, said, listen, in this type of sector, in this type of industry, there is more tolerated than not to have repeat appointments. This arbitrator, apparently, I think they took into account, if I remember correctly, and you read between the lines, that the reputation of that arbitrator was so robust, and they sided with the arbitrator who had said that he would be able to be completely, entirely independent in each case and exercise full judgment. Also, there was an element of the proceedings and the timing in the proceedings that the arbitrator explained would make it such that it's almost guaranteed that he wouldn't prejudge one or the other. So I think the element of the timing and the way the pace of the proceedings was set out that helped in that case.
Well, that was
So
interesting.
that brings up. Oh, I'm sorry, Luis.
No, I was going to say,
But
it was interesting
ahead.
because there the court even said he did violate his duty to disclose, but said that by
Exactly.
itself was not sufficient given the circumstances.
That is important, very important, because usually courts acknowledge that there is a duty to disclose and that breaching this duty not necessarily involves acting in a lack of independence or impartiality fashion. So those are the nuances that we have to get into, right?
Yeah, and that goes to, when do you have to make supplemental disclosures during the course of an arbitration, right? I mean,
Right.
complex arbitrations can take 18 months, 2 years in some cases. Over the course of it, you have busy neutrals that are involved in other matters.
And you have to decline certain cases if you're acting in one that is particularly sensitive or involving way too many counsel and parties and arbitrators that are indirectly or directly involved in others. It's better to decline cases, even if you're objectively maybe, or you believe you are independent. It's just better to pace yourself and to think in the long term. This is a marathon. Our careers are thank goodness we can be arbitrators for many years. So you just have to brace yourself for the big, long marathon that this is.
Following up on that, kind of related, the concept of arbitrators publishing. I remember I designated a former Secretary General of the ICC, but he had published something about the arbitration laws throughout Latin America. The opposing party said, oh, no, look, he published, and as I understand it, the ICC looked at that and discussed it quite heavily, but, went against the recusal. Would you advise that arbitrators not publish anymore? And to me, it's a tragedy because when I select an arbitrator, I select it for that person's knowledge, and every case is different. But the idea that a arbitrator is a tabula rasa, that has no knowledge about anything, is kind of ridiculous. But anyway, comment on, this, whether or not we should be publishing.
Yes, that is a great question. And when many years ago, I wrote an article, it's published on my website, where I thought issue conflict really doesn't exist. There may be an issue bias where you have a predisposition towards a position, academic position or view with respect to certain legal positions or analysis. And maybe precisely for that reason, you get on a case, right? And even you may be the only or one of the few experts in a specific sector. So I thought, at that time when I published, this shouldn't be a problem in a party appointment system, precisely because that is one of the factors parties need to consider to appoint an arbitrator. And I still think that way academically or conceptually, but I think in practice, you may be encountering problems if you are so specialized or so vocal or such an advocate for something that you get appointed increasingly as a wing party. And then I don't know if you get recused for that reason, but you will probably get one of two extremes. Either you are able to convince the panel on your positions because you're the expert, or you can get excluded from conversations, not literally because you have to deliberate with everyone, but you can be excluded from the opinion, from the decisions if you're so set on one position. Now, having said all that conceptually or theoretically, in practice, it doesn't play out that linear, right? It's not as clear cut because sometimes you publish something at one stage of your career and then you change your mind and you don't publish that you change your mind. Sometimes, you publish, for example, you're commenting a case, a decision, a court decision. Well, that's so specific. I still think issue bias shouldn't act as a freeze or a chill to publish and to study academically, but it should make us be careful with what we write. And I think it's more relevant in investor-state disputes when there are 6 or 7 elements that are common to usually the treaties that give grounds to the cases. So maybe in investor-state disputes, it is more sensitive.
Well, yeah, it's funny you mentioned that because I wanted to move to the concept of dissenting opinions. And it just so happens that in December, I issued my first dissenting opinion ever in an investor-state dispute.
So we should
Are
ask you the question.
dissenting opinions, should we write dissenting opinions? They're really of no, binding precedents. It's, I'm not sure what the effect of it is. Is it a sign of bias that you go ahead and issue a dissenting opinion? Obviously, I have my views, but
yes, this is a great question. I've only dissented once in a footnote on one particular issue, just because I thought I don't find, that there are grounds for this and I don't feel at ease. But then I don't know if I did the correct thing, because there are two ways to look at it, right? The first is arbitral tribunals are a collegiate body and the majority wins. So why would you need to dissent if you have 2 out of 3 people opining that A is right? Why would you dissent if you already know that the rule is that the majority will carry weight and that the important thing is that the deliberations are sufficient? Sometimes I think we need to pay more attention to deliberations and make that a more, systematic process. But anyway, that's another thing. Because sometimes maybe dissents arise out of the frustration of not having been heard to manifest something in writings to the others. But sometimes dissents are because you don't want to join for reputation or for consistency purposes an opinion that really goes against what you think and that what you've expressed before, which maybe is your case, Luis. You say, goodness, I don't agree at all with this. I don't want people to read that I participated in my first investor-state dispute and that this is my position, because it is not, right? So, and what if dissenting opinions are a wink to the party who appointed you? Because I don't know if you would write a dissenting opinion that would favor the party who did not appoint you.
Right.
So this is a bad sign of the system, right? Already. So Albert Jan Vandenberg did a study on this, and I'm sure you may be familiar with this article that he wrote years ago. And I think he has a point. So does it undermine the whole credibility, or is it something that we have to look out for ourselves? Again, how much is it about me? How is my mother working there or not? So what do you think, Luis?
I always thought of it as, in the past, I always thought of it as the dissent was just a wink to me that, sorry, I tried, right?
Right.
I was in there, I fought for you, and I tried.
Right.
No. But now I think, that, especially in an investor-state situation where the the opinions are published and people are relying on them. If you, in fact, want to continue to be involved in investor state arbitration, you want to make sure that you have properly articulated the position that you have. If it is very distinct from what the tribunal has
Right.
come up with, the majority
Well,
that the tribunal has come up
I think there is a distinction between investor state and commercial. There have been times in commercial arbitrations where, yes, I've dropped a footnote. This
Right.
is this decision is by majority,
Right.
and you may or may not want to disclose who was in the dissenting.
Right.
You may want to, on a particular issue, drop this is also by majority, and again, you can decide whether or not. When I issued the dissenting opinion, it's not really a wink to the party that appointed me. That wasn't my reason, but it is an issue that is being hotly contested. At one point, there was almost universal on one side, and then now it's there's a trend going the other way. And my view is, that's something of public debate, and the fact that, yes, this tribunal, and it was very fair. The tribunal chair is an eminently
Right.
una eminencia, but
Mhm.
he was very fair, and I think he struggled with the issue. He came down on one side, on the other side, but I thought that was important to contribute to the debate, because in an investor state, it's a little bit more. There's more public policy, and again, each case is different. The fact that I
Yeah.
dissented in that case doesn't mean that I wouldn't take another position if the facts or the treaty were a little bit different.
Right. And I think to contribute to debates, though, you would want to publish an article afterwards, for example. Why not?
Okay.
Right. But then, yes, I think this is very tricky because you're also dealing with this is my first case. Parties are sensitive. When they reach out to appoint someone in the following case, other law firms and other clients will look at the decisions that I wrote, and this will be turning against me eventually. But then you say, why don't I wait for 1 year and publish an academic article or comment? So I don't know the answer. I think we need to speak more about this in conferences and see whether we can come up with whether it's a problem at all, whether we don't or do agree with Albert Jan Vandenberg, or whether if we do agree, there is another way to look at it and deal with it. I think it's an important question. One of the most important things in investor state arbitration, because then the market can start looking and profiling, if you will, arbitrators who are one wing, arbitrators who are another, and who are chairs. Maybe it's good, or maybe it's not, right? So I don't have the answer, unfortunately, of course,
right.
as with many things
Well,
that we've been discussing, right? These are all gray areas.
we've abused a great deal of your time, and we really appreciate it. Let's try to wrap this up. What kind of advice to arbitrators and counsel navigating these conflict and bias issues? What advice can you give us?
I think that sometimes when you have a feeling that something should be disclosed, that something should be done or not done, maybe you should go with it. But often it's a very difficult decision. So the first thing is try to imagine what the decision one way or the other that you're taking would read on a blank piece of paper when you receive the GAR or the IA reporter or whatever news that you're reading, your news feed, and you think, what would I think of this situation? That helps sometimes in hindsight or taking a step back from yourself. The other thing is that arbitrators, we know one another. We like to give advice to one another. I sometimes seek advice from seasoned arbitrators without giving them information of the case. But what would you do in this situation? Arbitrators like to help one another. And just by saying it to another person, you already listen to yourself and you already help yourself. So don't be afraid to seek advice from others, being very careful, obviously with safeguarding confidentiality and private information. But that would be, I guess those are my two things. Make yourself sure that you can sleep at night and that you're in for a long haul, that your credibility is at stake, but also that the system needs to work. You can't over disclose and overdo your homework, because then you have to think of the consequences of that as well. You would be raising the standard for everybody, and you would maybe curtail everyone else's ability to have the systems in place that you have, or also depends on the jurisdiction where you are.
Very much.
One usually begins in a very jurisdictional specific community or case, and then you start evolving, and things change. The situations and expectations can be different.
Don?
I think that's great. I mean, that says a lot. We have a great community. I think reaching out to those in the community who have dealt with these issues, it's important to debate these issues. There's no clear answer. There's a lot of gray, right? And it's not all black and white. And as we move forward, I think we all have the same ambition to do the right thing and to ensure the integrity of the system in the future.
I want to follow up on what Don says, because this international arbitration has been incredibly successful. It's, from the New York Convention of 58, it's amazing and it's been successful ultimately because the arbitrators and the people who built it were people of incredible integrity.
Right.
The moment you lose integrity, which is what you're speaking to, the
Right.
moment you lose integrity, well, then the legitimacy is gone. Forget about independence and impartiality. If you don't have trust in the people who are doing this, well, we've lost everything, and that's what we have to protect.
Yes, because we are just a tiny part of it, and we are providing a service of justice to the community. This is not a market as markets are. We're not in any type of, not your typical service provider. We are in the process of giving justice and, enforceable binding decisions. This is pretty serious. So I agree with both of you.
For example, you're not like the hired expert when you're the party appointed on a tribunal.
Exactly.
You have an obligation to all parties and to the system as a
Exactly.
whole.
That is, Don, so important, because I missed that. You have an obligation to all the parties. You have an obligation to the dispute, not to the party who appointed you. Exactly.
Well, Dyala, I hope to see you in Madrid at the ICA Congress. Again,
Yes.
thank you so much. I couldn't be happier that you were our first guest.
Thank you.
And I think everyone who listens to this will be better off for it.
Thank you so much to both of you.
Dyala, it's been great talking with you, and I hope to see you at one of these conferences or something along the way.
3, 2, 1.